Johnson & Johnson has supported frontline health workers for 134 years. Today, we're here supplying meals, protective equipment, extra training, and mental health support. You're always there for us. We'll always be here for you.
I felt like when I took the full-time role, not only was it Walmart inviting me in to join the team, but I also felt comfortable here.
Over 95,000 temporary COVID hires hired permanently since March. Live better together. Walmart.
Welcome to the conversation on ethical policing. My name is Aurora Vasquez, and I'm a member of the volunteer working group that helped put together the concept of ethical policing and the sample legislation that goes with it. But before we jump into the meat of the conversation, I'd like to pause to say thank you to the National Black Caucus of State Legislators for creating a space at the table for us to have this very important conversation during this, the 44th Annual Legislative Conference. I'd also like to say thank you to you for being a part of this conversation. I'm confident you'll find the conversation around ethical policing is timely, but also helpful and hopeful, because we try to fill it with plenty of solutions to this problem of policing culture and policing violence that's impacting so many of us at this time, and which has impacted so many of us historically. I'd also like to say a special thank you to the staff at NBCSL for all their help and support during these past several months when the conversation around ethical policing has been unfolding. So many thanks to Wanzina, to Tanya, to Lamar, and to Wayne in particular for your help with this workshop. I'd also like to say a special thank you to Madam President Gilda Cobb-Hunter for her ongoing participation in and support and careful guidance to the volunteer working group. We are very much appreciative of that. And now a little bit about the working group itself. It's made up of 3 individuals: Donnie Charleston, whose specialty lies in policy research; Kelly Adams, whose specialty lies in government affairs; and myself, an attorney with a background in civil rights and racial justice and legislative drafting. Now, the 3 of us came together in the aftermath of the Breonna Taylor shooting and the George Floyd incident. And we came together with a question many of you probably asked yourselves, as did the broader community, and a feeling many of you probably had, as likely did the broader community. As to the question, we asked ourselves how it was possible that law enforcement officers who had a history of misconduct, if not aggression and violence toward and in community, which community herself well recognized, still had a job. We felt, however, simultaneously that it was very unlikely that the law enforcement officers involved in both of these incidents were ever going to face reasonable consequences or reasonable accountability for what they've done. So with those 2 things weighing on us, we came together to try to help craft a solution. Now, ethical policing is multifaceted and a little complicated, but definitely understandable. What I will say, however, is that ethical policing does not focus on individual tactics, so you won't find anything in this conversation or in the sample legislation that goes with it that focuses on banning, say for instance, no-knock warrants or chokeholds or carotid knee holds, though that work is very important and we're happy to see it happening out there. Ethical policing, I will say, as a complicated subject matter and a fairly new idea, can best be understood with 4, I think, simple concepts that'll help you wrap your mind around it before we jump into the meat of the conversation. And the first point is that ethical policing codifies law enforcement standards. And what we mean by that is this: it takes some of the best practices that currently exist in law enforcement profession and couples it with communities' right to expect consistent professionalism from the policing that is brought into her community. The second thing it does is that it sets a floor for professionalism. Very simply, it makes clear that police misconduct has no place within the policing culture or within the profession of policing. Third, it ensures that all members of law enforcement, without regard to rank, have a clear understanding of what is expected of them, and that they know what the consequences are for failing to meet those expectations. Now, I'll pause here to add that this combination of clear expectations and clear consequences for failing to meet those expectations does not only apply to the law enforcement officers who are out in community. There's also clear expectations and clear consequences for the supervisors and everybody on up the ranks. The consequences and expectations for them, we feel, are necessary because if they fail to act in response to acts of misconduct among their department, among the people they supervise, then all of us are at risk, including the community and the profession of law enforcement itself. And the fourth point is that through its various pieces, ethical policing institutionalizes respect. It institutionalizes respect for the profession itself. It institutionalizes respect for the laws that govern the profession, but also for the laws that govern the people who make up the profession. And it institutionalizes respect for the community in the way policing is brought into her midst. And this is all critically important because at the end of the day, ethical policing is very clear that any person who is incapable of engaging in ethical policing does not have a place within the profession itself. In short, if one cannot police in an ethical way, one does not get to be a police officer. And so our hope is that the sample legislation that accompanies this concept of ethical policing will be adopted around the country in each of your states, and that when woven together, it will prove to create a safer country for all of us, for our children and our children's children, but not just tomorrow, that all of this can begin today. With that said, let's go on with the rest of the conversation around ethical policing.
NBCSL is a solutions-based organization, and the Law, Justice, and Ethics Policy Committee created the Ethical Policing Work Group. They have developed a policy framework to provide solutions to the problem. It is the committee's intent that members will introduce this ethical policing reform legislation in their respective legislatures. So some housekeeping items before we begin. We will have a Q&A session at the end of the presentations. So if you would like to ask a question, look to the bottom of your screen and click the Q&A button. You can type your question there, or you may send it in the chat to the panelists. You may also, during the question and answer session, raise your hand and we will acknowledge you for a question. Lastly, all materials will be provided on our website for future viewing. So we anticipate great information today and encourage your full participation. Michael Dean, Christopher Whitfield, Melvin Watkins, Tommy Smith, each sole named was an African-American male shot to death last year by a police officer. President Cobb Hunter's theme this year is creating systemic collaboratives to improve our community's future. So today we will hear from Madam President, along with Donnie Charleston, Kelly Adams, and Aurora Vasquez. Once they have finished, the question and answer period will be led by Tanya Cook, our policy lead and former Nebraska Senator. So Madam President, I now turn it over to you.
Thank you, Wanzina, and thank all of you who are on the call. We really appreciate you taking the time to hear a bit more about this new idea that we are terming ethical policing. We hope that you will give it some thought, and in the event that you think it makes sense, that you'll help us push this. And we'll come back later with more along those lines. And so when we talk about ethical policing, I'm sure some of you, before I go into that though, let me again reiterate that this is a product of the Police Reform Work Group. This is also being done through NBCSL's Law, Justice, and Ethics Committee. NBCSL is a solutions-based evidence-based organization. And one of the things that we do, the only thing that we do that really establishes policy, is pass resolutions. Resolutions dictate what NBCSL takes action on. I am pleased to say that thanks to the work of this team, the work group, and the Law, Justice, and Ethics Committee, led by Representative Gregory Meeks of the great state of Kentucky, led by Reginald Meeks from Kentucky, as well as I'm sorry guys, I just had a technical issue that I apologize for stopping in mid-sentence. But as I was pointing out, the ethical policing resolution has been adopted by NBCSL's Law, Justice, and Ethics Committee. And we are really pleased to be able to talk to you this evening about what it is. We had, along with the work group and the committee, I also want to give a special thanks to Representative Ray Hall, who is from, I'm still getting feedback. I'm not sure what the issue is. I will try to muddle through this without too much feedback, but it is when you are technologically challenged like I am, you have difficulty understanding which button you should push. But at any rate, we are here to talk about ethical policing, and we've got, you see before you a slide that says codifying standards and expectations. And really all we're saying here with ethical policing is that this is something that ought to be codified. And by that mean, what we're talking about is putting systems into place, putting it into law, putting it into statute, putting it into regulation. What we'd like you to remember about ethical policing is that this legislation simply codifies high professional standards and expectations. In other words, we have here a framework which will allow police officers to know what expectations are. Want to say from the outset that we see this as a companion bill to what is being done across the country. A number of our colleagues in states around the country have worked on legislation and have put things in place. What we know is that this is great, but it won't work without a framework. And so I want to just take a minute, if I may, to talk to you about what that framework looks like. And what we're suggesting to you is that the legislation, which we are hoping will be introduced around the country, takes the guesswork out of this for police officers. And what do I mean by that? If you have something in place that is clear, that says what your expectations are, this is what we think makes sense. If you go to the next slide, please. Now, this is a definition of what ethical policing looks like. And hopefully you will see here the answer to the questions, why ethical policing? Police malfeasance harms people and the profession. And quite frankly, what we're suggesting here is that when you have cops who do wrong, that their harm is not only to the people that the violence is perpetrated upon, but it's also a mark against the profession. We start out with the premise that most police officers are, for the most part, good police officers. Their intent is to indeed serve and protect. Unfortunately, there are police officers who don't have that as a part of their intent. Current policies, current policing practices and policies undermine community trust and public safety. And we're seeing a lot of that across the country. Juanzina started out listing names of Black men who had been murdered. I think it's important for us to know that this is something that happens not just to Black men, but also to Black women, and it also happens in brown communities as well. We believe at NBCSL that there is a great urgency to bring about, to restore community trust in public safety. And so we also know that because this is a transformative, you will raise the slide a bit, Wayne. Could you, okay. I apologize, guys. This is, it's been a long day. This is my 5th Zoom call. So Wayne, could you put the thing back up, or is it me? Could you put the slide back up? Okay.
It's up, Madam President, it's up.
Okay, I am so sorry. I'm not seeing it on my, I don't see it. Okay, thank you. I'm so sorry. America needs to institutionalize a law enforcement culture that normalizes fairness, equality, respect for human life, and dignity. And all we're saying here is that there is a need in order for everybody to know what the expectations are. When we use the word institutionalize, what we're suggesting is we need to make sure that whether you live in South Carolina, Ohio, New York, or wherever, that there is some standardization as far as expectations. We need to move toward making sure that the law enforcement culture is restored and is beyond this system that we seem to have in place in a lot of communities, where fairness, equality, and respect for human life and dignity does not necessarily seem to have doesn't have a big role in the communities. We need to codify accountability and transparency. As you hear from other presenters, what you will hear are specific ways that we have in the proposed legislation, which will codify, in other words, put into law, transparency and accountability. We believe very strongly that law enforcement ought to be accountable to the public that it serves. One of the things that we really want to make sure is clear is this idea of transformation. And so the question has been raised, well, we're doing a whole bunch of things that we think are reforming the police. And at NBCSL, again, we applaud all of those efforts. We have absolutely no issue with no chokeholds, barring chokeholds, making sure that no knock warrants are in all of those kinds of tactical efforts that are underway. We believe that ethical policing is a great companion piece to go along with all of those kinds of changes, because as you will hear further along in the presentation, all of those kinds of things are tactical processes. We believe that while that is great, if we don't have the foundation, the framework that this ethical policing is putting forth, that you will constantly be monitoring and changing tactics. We operate this ethical policing, we approach ethical policing from the framework that we have to make it clear what expectations are for our police. And this is something that we believe very strongly needs to happen. Next slide, please. And so I've talked a lot, rambled a bit, but let me tell you what we have in legislation. Next slide, please. That we say is ethical policing. And what you see before you is the language that is in the legislation. We are suggesting that ethical policing is the discharge of responsibilities stemming from employment as a law enforcement officer, which is devoid of police misconduct and which is carried out in conformance with the duty to safeguard life and the duty to intervene. And so what we're saying here, quite frankly, is we expect that if you are a law enforcement officer, that you will not engage in police misconduct, and that you will carry out your duties and responsibilities, understanding your obligation to safeguard life, and also understanding your obligation to intervene when there is something going on that is not appropriate. And so I want to, before I turn it over to Donnie Charleston, I want to share with you that we are using language here, such as a law enforcement officer. That applies, that language is being used, but it applies across the board to any rank, starting at the top and all the way down. So it's rank and file, it's also supervisors and all of that. And so I will now turn it over to Donnie Charleston to continue the conversation. Thank you.
Thank you, Madam President. It's an honor and a pleasure to be with you all today. And so my role here today is to talk to you a bit about police misconduct. And so Madam President talked a bit about, what we're trying to do here with respect to ethical policing. So the question is, what are we trying to curtail? What are we trying to police, to coin a phrase? And that's police misconduct. And when we talk about police misconduct, as you can see there, we list out some activities there, and I'll read that first sentence in italics. Police misconduct is conduct that violates ethical policing or the policies and standards of the employing police agency, including the following conduct. And so we specifically carve out those activities for a reason. I'll get to that in a second. But what I want to draw your attention to is that when we talk about police misconduct and how we're framing it here, please know that police misconduct is defined here within the context of the federal law enforcement statute. So we're talking about 18 USC section 242. Nothing that we're framing up violates what the federal government already holds police departments accountable for. When we talk about 18 USC, that statute states that whoever, under color of any law, willfully subjects any person to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States shall be guilty of a crime. And so, as you see here, listed on this slide are a number of actions and behaviors that violate both the letter and intent of that law. So excluded from that list, this is another thing to note, are those activities that are also fit under police misconduct, but are crimes that all citizens are subjected to be prosecuted for. And so we're talking about physical and sexual assault, alcohol-related crimes, theft, and so forth. And I make a note of that because those are crimes that officers can be charged with as well. And we look at the actual research. We look at the Department of Justice in 2016. They commissioned some research that looked at all of the crimes that law enforcement officers themselves are typically charged with. And when we look at the major categories, we're talking about simple assault, constitute 13% of the crimes that police officers are typically charged with. Driving under influence, 12.5%. Aggravated assault made up 8%. Forcible fondling made up 5%, and enforceable rape made up 4.8% of the crimes nationally that law enforcement officers are typically charged with. But that particular research, like I said, it was pretty informative, but it did not separate the crimes out by whether or not the crimes were executed within the officer's official capacity, or whether they were crimes that were done in, for example, while that officer was in his civilian capacity. But herein, I note that because herein the focus is on misconduct that occurs within the execution of official duties and impinges upon the rights of other citizens. More importantly, these common crimes are not, these common crimes we talk about driving under influence and so forth, those are crimes that aren't intertwined with the systems that have been demonstrated to be contributing factors in increasing law enforcement misconduct. Namely law enforcement unionization and other systems. When we talk about the systems that are in place with respect to contracting and so forth in states, sometimes we found that the research has found that those systems can be problematic. A 2008 study from the University of Chicago Law School examined severe misconduct complaints against sheriff's departments in Florida before and after the department had the capacity to collectively bargain. And what they found is that after the sheriff's departments gained the capacity to collectively bargain, they saw an increase in 40% in complaints against law enforcement officers after they have the capacity to unionized. So that may be something that's just specific to the state of Florida, but it is something that we need to be attentive to when we look at how we can increase accountability and transparency. What we know is that we need to look specifically at those structures that are in place in most states, that is, that actually protect law enforcement officers, although many of those policies and procedures are put in place with the best of intent, they do have sometimes negative externalities that we also need to look at as a nation and look at them case by case in each community. So given that reality, that's why we think it is important to be clear about the expectations and what actually constitutes misconduct. Next slide, please. In an earlier slide that Madam President laid out, it laid out the definition of ethical policing and couched it in terms of the basic responsibilities of law enforcement, of a law enforcement officer, that is, namely two things: the duty to safeguard life and the duty to intervene. So it's important to note that neither of these basic expectations of law enforcement go beyond what is implicitly expected of law enforcement agencies. So what we are framing up here is nothing that isn't already framed up in most of your police departments across the country. If you look at their mission statements, they include very clear expectations regarding the duties of a law enforcement officer to safeguard life and the duty to intervene. And so we're going to talk for a brief second about the duty to safeguard life. This definition that we are looking at here, when we talk about safeguarding life and what constitutes misconduct, makes explicit that the expectation that misconduct is a violation of those basic police norms that I just laid out. And what we typically see in the law enforcement context is an emphasis by those agencies, and even beyond the agencies, we talk about governance officers, legislators, mayors, and so forth, is an emphasis on the execution of police activities. And so they emphasize the discharging of duties in the public interest. They emphasize obeying department policies, but without the emphasis on preventing misconduct. And that's something we think needs to be addressed across the nation. So of course, the natural argument that arises is that it's difficult to police the police, so to speak, with formal laws because of the culture of police departments. That's an issue that constantly comes up when we talk about how we reform law enforcement activities and create better systems that are responsive to citizens' needs because of that culture. And the research actually bears that out. But I want to note that what we found also through research is that when departments integrate policing models that explicitly focus on preventing misconduct and integrating those practices into the fabric of a department, it can lead to reduction in a number of negative outcomes. So what we know is that those systems that focus on increasing attentiveness to malfeasance and putting in the right structures can decrease things like vehicular collisions by law enforcement officers, can decrease injuries to law enforcement officers themselves. And also, most importantly, it can decrease the use of excessive force by law enforcement. So we know that these procedures can be impactful. New Orleans is one of the leading entities in the nation on this front. They implemented an initiative a few years back called Ethical Policing is Courageous, with EPIC being the abbreviation, of course. That initiative is a clear example of this model's efficacy and is working quite well in New Orleans, and they're actually replicating it in other states, starting to replicate it and look at how to replicate rather across the country. Next slide, please. Next, we have the duty to intervene. Once again, it's already an expectation in federal law, 18 U.S.C. Officers can be charged for violations of an individual's rights if they fail to intervene under already established federal law. However, what we find is that there's no uniform policy in place in police departments across the country regarding an officer's duty to intervene. In the wake of George Floyd's death, we saw a number of police departments across the country, including my home state of North Carolina, city of Charlotte, implement policies regarding a duty to intervene after they witnessed the actions of those junior officers in the George Floyd case, where they did not intervene and prevent George Floyd's death. And so we've seen departments, like I said, step up and start to implement those policies because they recognize that there is a true need to put those things in place. The definition, the framing rather, of ethical policing advance here, and what we're encouraging police departments to adopt are definitions of ethical policing that call for every department to make explicit that an officer has that duty to intervene. And this model lays out a number of protections for officers who come forward in those instances where they report the misconduct of others. And so when we look at the model, you see that there are a number of provisions that the model advocates for that most people will be familiar with when you think about whistleblower protections. And essentially what we're talking about here is instituting those types of protections for law enforcement officers such that they feel that they are protected and that they won't be losing their jobs, that they won't be the subject of retaliation in their departments. Many of you may be familiar with the Christopher Dorner case in Los Angeles a few years back, where he was a Los Angeles sheriff's officer who had reported police misconduct and police brutality, and he felt as if his fellow law enforcement officers had turned on him. And this individual went actually on a spree and ended up shooting and killing some of the family members of some of his fellow officers because he did not feel like he had, in part, the ability to report malfeasance. He didn't feel like he had the protection necessary in the system. And so that was an incident of officer-on-officer crime that it would have been wonderful if, as a nation, we had the necessary protections in place to prevent that horrific crime in the city of Los Angeles. So that's kind of the framing for what we're laying out here. And then we hope that that provides you with a little bit of insight into how this system is framed up. And I'm going to turn to my colleague, Kelly, who's going to talk to you about how this exactly works.
Thank you, Donnie, and thank you, Madam President. First, it incorporates familiar policing policies and practices. Donnie just talked about duty to intervene. This is a familiar concept to law enforcement profession. The legislation codifies it. Early warning systems, best practices used to track complaints, the legislation also codifies. And standard complaint forms, which requires every agency to use the same form, same template, consistency in reporting. The legislation clearly defines what information must be recorded. Next slide. Second, expectations are clear. Madam President talked about this early on in terms of next steps and making sure people are clear, and accountability and transparency are large parts of this piece of legislation. So as it relates to upholding the duty to intervene, it requires action, right? It prohibits retaliation from reporting. Donnie talked in depth about and gave the example. Implementing early warning systems. It requires the system to be used. It requires accessing it. Those accessing it, to be informed of their obligation to use it. And then utilizing the standard complaint form. It requires complaints to be taken and the form updated to show outcomes. And it makes the form, or parts of the form, the information, public record per se. Next slide. Thirdly, consequences are clear. If duty to intervene is violated, consequences for those who violate the duty, those who fail to report a violation, those who refuse to take a complaint. Early warning systems, consequences for those who fail to create and use the system, and those who fail to take action in response to patterns of misconduct. Standardized complaint form, consequences, those who refuse to take the complaint, those who refuse public inspection, and those who fail to record available information. Threats, this treats this as a severe violation, that is, failure to meet expectations equals a violation in ethical policing. So I'll turn it over to my colleague Aurora to go over further details about the bill. Thank you.
Thank you, Kelly. And thank you, Madam President. Thank you, Donnie. Thank you to the NBCSL team, to Wanzina, to Tanya, to Wayne for helping to make these webinars successful. It's incredibly exciting to be able to have this conversation with everyone. So now you heard Madam President and the rest of the team talk about why ethical policing, a little bit about what ethical policing is. We actually looked at the definition of ethical policing, and you heard Kelly talk about how ethical policing works, for instance. So the next natural question is, well, what's the consequence, right? If somebody does something wrong, if someone is found to be in violation of ethical policing, what actually happens? Well, in the model legislation, we've taken time to define what happens. We've defined the consequence, and we try to be very clear and very firm. Part of our goal is to be transparent about what we're trying to achieve here, about the standards we're setting and what's expected. We're not trying to create sharp edges or blind corners for law enforcement in order to make their job difficult. We're trying to do quite the opposite and be as transparent as we can in the expectations and the standards we're setting. So as that relates to the clear consequences for violating ethical policing and the words we chose for the language you see here, we made it very clear, and it's very simple. If you are incapable of, or if you choose not to engage in ethical policing, then you no longer get to be a member of the law enforcement community within the state. So notice we didn't go small. We didn't say you no longer get to keep your job at the particular police department that you work at. We said you no longer get to be a part of law enforcement in the state. And the reason we did that connects to our goal of being very transparent and clear, but because ethical policing and the standards that it calls for are critical to the profession and also to public safety. And so it's important to create a system that ensures that police officers who fail to live up to ethical policing aren't able to outrun their misconduct reports, for instance, because sometimes we see that happening, right? So there you have the definition. You'll find that in the model legislation. Next slide, please. And so now we'll take some time to delve into some of the other aspects of transparency and accountability that you'll find within the legislation. And relating back to what Madam President said in the beginning, and in fact, something that Donnie and Kelly also touched upon, that most of the legislation, an incredible percentage of it, I won't say all of it, but most of it is in fact grounded in things that policing profession are already familiar with. And so you heard some of them, and here are some others. Citizen review boards. We don't claim this to be a novel thing. In fact, it's already, citizen review boards already exist in many jurisdictions. What we're doing, again, is codifying, because that's what we're trying to do in order to create uniformity, right? So there are no surprises for anyone. The goal here is uniformity across the state. And once this legislation gets introduced and passed in multiple states, there will be uniformity across states and eventually, hopefully, uniformity in policing across the nation. So that's the ultimate goal. But back to the matter at hand, uniformity within this piece of legislation, citizen review boards. We gave them a lot of thought and we gave them clear responsibilities. All their responsibilities are not outlined on this slide here, but they are in the legislation. And we thought about the responsibilities in connection with what we want these citizen review boards to be. And we really wanted them to be a bridge for community to participate in ensuring the emergence of the type of community safety community wants for herself. And here's what I mean by that. It's not enough to get us to where we want to be in terms of community safety and better relationships between policing models and the lives of human beings, right? It's not enough to just draw up a list of the things we want law enforcement to do or the things we want them not to do. Similarly, it's not enough for community to draw up a list of the things she wants without also kind of rolling up the sleeves and getting behind it to help facilitate the emergence of it. So we hope that citizen review boards will be that place where community's ideas can be facilitated for success. So what we did as it relates to membership for these boards is we ensured that the age participation would be all the way down to 16-year-olds, to include teenagers, right? For a number of reasons. One is transparency. The other is obviously they are members of community, and youth have ideas on how they want safety in their community to look. But these citizen review boards are also an opportunity for leadership, right? So if we can get youth onto these boards and get them invested in pushing the manifestation of the vision they have for community safety and community police relationships, then we as the grown-ups who are in the unique position to be able to write laws that are going to formulate youth lives as they grow, have created a space for them to become leaders and to be able to facilitate the success of the legislation and the laws that we draft and pass, for example, as grown-ups. So there's that. We're also very clear to prohibit the participation of law enforcement officers and any member, any employee of a law enforcement agency, for example, on these citizen review boards. And the reason for that is simple. We just want to avoid the chilling effect that may have. And another thing we did is that we have prohibited nepotism through this lens. We have written in language that clearly states that multiple members of the same family unit may not sit on the board at the same time. And the reason we did that is because we wanted to avoid a circumstance where a small board, let's say a 5-person board, is staffed by mother, father, and daughter. Because people who are closely related in family tend to group together in the way they see things, right? And so they might group together in the decisions they make for the board, in the way they vote on matters for the board, leaving the other 2 members out. So we wanted to avoid that type of kind of barrier to full participation. So we're preventing family members from serving on the board at the same time. And there are other portions to the definition of who qualifies as a member, and that's also in the model legislation. Now, we also did something interesting with where these boards will live and be formed. We are giving community the option of creating the board in one of 3 places: at the local level, at the county level, or at the state level. And the local level is for cities with at least a population of 10,000, and it gives them an opportunity to form a board and to have local people. The people who sit on that local board would have to be from that local city, for example, to really have eyes and ears and to be thinking about policing in relationship to the local community. But now let's say that a city that qualifies doesn't want to create a board at the local level. Well, then there's the option to create a board at the county level, and membership will be pulled from individuals who live within the county. However, the county board will not have responsibilities over any city that has chosen to create a board at the local level. In other words, a county board will not usurp a local board. It will only be responsible for those cities that could have formed a local board and chose not to. But now let's say that there's an entire county with cities that are potentially eligible to form a local board, and they've all said, no, thank you. And then nobody at the county levels has raised their hand to say, well, we'll do it at the county level. Then a board can be formed at the state level, and membership for that board could be pulled from the entire state. And similarly, that state board will not have responsibilities over any place that has a local board or any place that has a county board, for instance. The downside of a state board, I'll be frank, is that membership pulls from the state. So it may be the case that a state board will be examining issues happening in a particular city, but there may not be anybody on the state board who actually lives in that city. So there could be a bit of a disconnect there, right? Hence, we created the options of local, county, state, so that we could get as much local perspective onto these boards as possible. And also so that the responsibility of really digging into police misconduct and police and community relationships doesn't sit with, say, a team of 5 or 7 people at the state level who are responsible for every city in a state, because that can be pretty overwhelming and might in fact be ineffective, and we want to avoid that. Another thing we've done in this legislation is that we have talked about disciplinary actions separate from police misconduct. And here's what I mean by that. We recognize that reports of police misconduct will result in or may result in disciplinary action. In any event, a report of police misconduct is going to result in something. And that whole process from the report to the something it results in will be recorded on the standardized complaint form, as Kelly noted. But then what if there's a department or an agency out there who, in an effort to avoid disclosure of information, because Kelly said very clearly, the information on the standardized complaint form is public record per se. There will be no debate about whether the public gets that information. They will, right? No need to litigate it, no need to hesitate. They are entitled to it, as is the Citizen Review Board. So what if an agency, in order to avoid disclosure, tries to get ahead of a formal report by responding to the information it receives about misconduct and deciding internally to impose disciplinary action, right? They have circumvented an informal report. Well, we thought about that. So we said any disciplinary action that gets imposed also has to be recorded on a standardized complaint form. And if there isn't a formal complaint attached to it, then the agency has to record on the standardized complaint form the thing that precipitated their decision to impose disciplinary action. And we don't care what you call it. You may not call it disciplinary action, but if it's an act imposing discipline for some kind of conduct, then it needs to be recorded on that standardized complaint form, and it's going to become public record. So we tried to anticipate some of these potential different perspectives on what it means to disclose information for the sake of transparency. Next slide, please. And here's some more features of the bill. We've been very clear language in it that says these complaint records, these police misconduct complaint records, information will be on the standardized form, must be made available to other agencies who ask for it. And so if you think about it, if all the information lives on a neat standardized complaint form, there's going to be no problem in just pulling up the information and handing it over, right? Plus, it's going to be public information per se, so they're entitled to it. But we also went one step further and gave clear instances in which this information has to be shared, but also sought. So for example, if a department or an agency is considering hiring somebody, say a brand new hire, we're not talking about a transfer or anything like that, a brand new hire, new offer of employment, before they can make that offer of employment, they have to request that individual's police misconduct records if they are have a history of being in law enforcement, right? They have to request them. In fact, we went so far to say that if they request them and determine that there are no records, they have to certify that very fact. So in other words, you don't get to not request the records and then somewhere down the road say, oh yeah, I requested them, but there just weren't any. No, the requester has to certify in writing that they requested and that there were no such records. And the reason we do that is because if down the road, this person they hired engages in police misconduct, and it turns out they had a history of police misconduct, then there's mechanisms in the bill to prompt accountability for the law enforcement officer and for the person who was supposed to have obtained the records, okay? But we also require access to those records, so you have to ask for the records or provide the records in the event of a transfer between department to department, between precinct to precinct, from one policing agency to another. And the reason for that is, as I said earlier, we're trying to prevent individuals' ability to outrun their misconduct records and outrun accountability and outrun consequences by simply transferring to a different place, whether that place is somewhere else within the state or across state lines. Hence, the records are available to any policing agency. It doesn't matter where they are and in what state, to any policing agency. Short form, your records will follow you wherever you go within the law enforcement profession, right? Another thing we do in the bill is that we make it very clear that for every law enforcement officer who engages in any kind of training, licensing, or certification, part of that process has to include teachings on ethical policing, what it is, the standards it requires, and then the individual would-be officer or new officer has to acknowledge in writing that they are going to engage in ethical policing. So some kind of a affirmation or attestation to that fact. It also has to happen at the point of retraining, relicensing, or recertification. Attestation, accountability with signature. So again, so that there's no question and there's absolute clarity to both the law enforcement officer and the agency that is employing them, that this individual knows what is expected of them and is committed to engaging in ethical policing. Next slide, please. And just a few more things that are within the bill that are also about transparency and accountability. We have language in there for summary data. Now, you heard Kelly and I talk about how the information on the standardized complaint form is going to be a public record per se. And so community and the Citizens Review Board, for example, will be able to access that information whenever they want. However, we're also making summary data requirement of the legislation so that we can create a snapshot of what is happening across the state, right? Because standardized complaint forms are going to be available within your backyard and you'll know what's happening in your community. But what if you want the big picture? Well, summary data will do that for you. And summary data reports aren't new either, right? Not novel. They are very familiar to the law enforcement community, however, because they are required in many states and in many sub-jurisdictions within a state. But what's interesting about our requirement is that we have said very clearly that as you're releasing this, this data disaggregated by the type of violation and how many violations, for example, that where there is a sustained complaint against an individual law enforcement officer, the summary data has to name that law enforcement officer and some identifying information for them. So for example, their rank or their title, that kind of a thing. It also has to identify what the violations were, and if they have more than one sustained violation against them, it has to say that. Now I point this out because in many of the current iterations of the release of summary data, law enforcement has done a really good job of ensuring that this summary data does not actually name individual law enforcement officers who have been subject to police misconduct complaints. And what we do is the exact opposite of that. Again, for the sake of transparency and for the sake of clarity, and because this information is already public record per se, pursuant to the standardized complaint form, there's absolutely no reason to not include it in the summary data. And it's also disaggregated, for example, by race of a victim. So if we're talking about excessive use of force, for example, a sustained complaint alleging excessive use of force, for example, then the disaggregated data as it pertains to that would include the officer's name, but it would also include the race of the victim, for example, so that the snapshot it's creating is quite clear about who is engaging in what and what members of the community are being impacted. And now another point that I'll touch on, and this will be the last one before we open it up for questions, is the concept of professional liability insurance. In the model legislation, there's a small portion dedicated to this topic, to professional liability insurance. And in that section, it calls on individual officers to carry this type of insurance, and it requires uniformity across that obligation, meaning we ensure that no individual officer or group of officers can be required to carry higher levels of insurance than other officers in their unit or in their department or in their particular agency, so that there's fairness across that requirement. But here's what I will say about professional liability insurance, that this is likely within the bill, probably the most controversial portion of the bill. Like we said, everything else is really grounded in things that the law enforcement profession is already deeply familiar with. In fact, many of those things live in their best practices and in their agency policies. So law enforcement officers already have to abide by them. Anyways, we're just legislating them. The reason this is probably the toughest portion of this bill is that in many states, if not all states, there's already existing language around indemnifying police officers for their conduct while they're on the job. And so in order for this particular subsection of the model legislation to succeed, individual states would also have to examine their indemnification language and would also have to make changes to that language in order to allow for a requirement of professional liability insurance to go forward successfully. And I suspect that that might be a bit of an uphill battle in some states because the law enforcement community feels very strongly about that type of indemnification. And you can see why. I mean, law enforcement, the job of policing is very dangerous in and of itself. So you can see why they feel like the least a state could do for them is indemnify them for their willingness to step into this role of policing. But what we're talking about is a different lens, right? Because it's also true that some police officers engage in misconduct. And so we have to strike a balance here. But this team wanted to be transparent about the changes that would have to happen to existing state law as it relates to this one particular piece about professional liability insurance.
Thank you, merci, and danke.
Thank you.
Thank you.
Thank you.
When they told me it was multiple myeloma, I knew I was in for it. Everything you hear about African Americans and cancer didn't help either. But you know something? I didn't let it stop me. I did my research and worked with my doctor to learn about my options. With myeloma, you can't back down. You gotta keep it moving. When they told me it was multiple myeloma, I knew I was in for it. Everything you hear about African Americans and cancer didn't help either. But you know something? I didn't let it stop me. I did my research and worked with my doctor to learn about my options. With myeloma, you can't back down. You gotta keep it moving.